All right, good morning, everybody. We're on the record for Magistrate Court this morning. I'm looking at the main jail. Do we have a Michael Boatwright there? All right, Mr. Boatwright, can you hear me okay? All right, I can't hear him.
Speakers might be off.
Mic check over there at Maine.
Oh, can you hear me now? Can you hear me now?
All right, that's
Hello?
better. I got you.
You hear? All right, good morning, Judge.
All right, good morning. Good morning, Mr. Boatwright. You're currently being charged with 1 count of first-degree premeditated murder. The court does find probable cause. Any argument?
Your Honor, Eric Linder on behalf of the state. I'm going to be seeking a finding of proof evident or presumption grade on this capital offense based on the arrest warrant affidavit prepared by Detective Curcio of the Broward Sheriff's Office and seeking a no bond hold.
Any additional argument?
Brian Reedy from the Public Defender's Office on behalf of Mr. Boatwright. I have reviewed Detective Curcio's affidavit. In light of the fact that Mr. Boatwright is currently being held no bond on several violation of probation warrants, we will reserve any argument regarding proof evident presumption great until he can appear in front of his division judge.
All right,
I would
thank
at this time invoke Mr. Boatwright's Fifth Amendment right to remain silent. I would ask that the state and any agencies of the state not contact Mr. Boatwright, attempt to interview him, or speak with him or in any way. Mr. Boatwright, I am advising you, sir, that you are not to speak to anyone about this case except for your attorney. All of your telephone calls from the jail are being monitored and recorded. If you discuss anything about the case on the phone to anyone, it will be used against you at trial later. If you discuss anything with any fellow inmates in the jail, you can expect them to be on the witness stand testifying against you at some point in the future. Do you understand?
Yes, sir.
Okay.
All right, sir, at this time, the court has reviewed the warrant and attached affidavit. It says find proof evident, presumption great. We'll hold you no bond. All right? You'll see your division judge. Ms. Lindsay Saltzman.
This private counsel judge who was here a few moments ago.
Saltzman, first case.
Who was brought here to Maine, Judge? Your private
All right.
attorney is there.
Good morning, Ms. Saltzman. You have a private attorney? Oh, please.
Miss Edwards?
Good morning,
Judge,
sir. If you
good
want to go
morning.
ahead and announce your appearance.
How are you? John Castellano on behalf of Lindsay Saltman.
All right, Ms. Saltzman, can you see your attorney in court today?
Yes.
All right, at this time, I have before me 1 count of violation of domestic violence injunction. Mr. Linder, I do see every indication in the PC that the actions speak solely to the mother-in-law's or the grandmother's sole actions. I don't see any indication that she was acting at the behest of her daughter. Do you have anything else?
Your Honor, one moment.
John Green?
I would be relying upon the allegation where it says, one moment, Your Honor.
Do you have an attorney? You want to hire your own or do you want to publish attorney?
The first sentence of the third paragraph, that while it doesn't specifically state that Ms. Saltzman asked her, Your Honor, I think it circumstantially can be argued that when her mother stated she picked up the child because the defendant wanted to see him after being away from him for 6 weeks, but she was not allowed to do it herself. Clearly she was acting on her behalf and stating that she wanted to see the child, how, there was obviously communication between the two.
All right.
Judge, the
Any
mother,
response?
Yes, Judge. The defendant's mother has been in constant contact with the father of the child, has gone to see the child, has been in communication. I've seen the text messages. This was not at anyone's behest. It was something the grandmother was doing for the mother to see the child, absolutely. But it wasn't requested, and there's no allegation specifically to that. I'd ask that she be ROR'd.
All right. If the officer has any non-speculative evidence in that regard, I'll give the state 48 hours to perfect.
Judge, is she going to be ROR'd today then?
She's going to be held until the state perfects the PC.
Judge, my concern with that is that
The PC.
48 hours from now is obviously the weekend.
I have no problem with
24 hours.
I'm fine with 24.
All right, 24 hours to perfect.
Thank you, Your Honor.
Ms. Alston?
Melvin Henderson?
Mr. Henderson is here at Main, Judge. He's approaching.
Good morning, Mr. Henderson. You're charged with 1 count of domestic assault, 1 count of resisting officer without violence. The court finds probable cause as to both, $2,500 on each count. No contact with the listed victim, Brianna Canio. Thank you, sir.
Judge, if I could be heard.
Go ahead.
And being Mr. Henderson, he's 22 years old. He's been here in South Florida his whole entire life. I believe he does have a minimal prior record, Judge. He lives separate and apart from the alleged girlfriend. He's living in Westbrook with his mother. Judge, he's a security officer by trade. He makes about $10 an hour. He just started working there. So the $2,500 bond on this, I believe it's a second-degree misdemeanor, is something that he may not be able to afford. I'd ask you to consider a $1,000 bond on count 1, Judge.
Any prior record?
Your Honor, Mr. Henderson was arrested last year for domestic violence battery against the same alleged victim. That charge was dropped.
Same victim?
Same victim.
Sign with the SSR, this is Sam Hoke, for the limit. Do you have any children? Yes.
All right, sir, if he wants to go on pretrial with GPS monitoring and no contact, I'll consider reducing the bond to $1,500 each count.
Judge, I believe the first time you said it was $2,500 on count 1.
Correct. On
So
each
you'll
count.
just accept the 20. Oh, on each count, you said.
On each count.
Okay. Hold on.
And, Your Honor, if possible after this case, if could we take a case at a term as private counsel?
Sure. Morning.
Judge, respectfully, then you'll leave the $2,500 on each count.
All right, probable cause found, $2,500 on each count. Thank you, sir.
Your Honor, if we could call Zachary Bleiweiss. He is on page 19 of the document.
Did I get a copy of the document?
He's approaching, Judge. He's here at Main.
All right, give me just a moment.
Oh, is that your turn? Okay. It wouldn't surprise me. I believe that's your private counsel.
All right, good morning, Mr. Bleiweiss. Good morning, sir. If you want to announce your appearance.
Good morning, Judge Arnold Blostein. I'm here for this hearing for Mr. Bleiweiss. I have not been retained yet, but I have spoken with his father. We're in the process of doing that.
All right, Mr. Bleiweiss, you're currently before the court on a total of 8 counts. Exploitation of a minor by computer services and failure to report as a sex offender. At this time, the court is finding probable cause as to each count: $250,000 on count 1, $250,000 on count 2, $50,000 on count 3, $50,000 count 4, $50,000 count 5, count 6, count 7, and count 8. I'm sorry, a total of 12 counts for you. Count 9, count 10, count 11, and count 12. All right, anything you want to tell your client, sir?
Yes, do not speak with anyone about your case. Anyone in jail, any police officer, do not talk on the phone. Those phones are monitored and will be used against you. As soon as your dad retains me, I will be up to see you, but he is working on it. Just don't talk to anybody.
Your Honor, may I be heard as far as additional release conditions?
Sure. Go ahead.
Your Honor, in addition to the monetary bond that was set by Judge Aballo and the arrest warrant, the state would be seeking additional conditions. Should Mr. Bleiweiss post these bonds, that he be supervised by pretrial release GPS monitor level 1, that he have no contact with any minors, and that he not be in possession of any devices with internet access. Your Honor, in addition, just so the court's aware, the reason I'm making this request, in addition to the allegations before the court in the warrant, Mr. Bleiweiss pled out a case of similar charges. There were approximately
Michael Parker?
I can tell you, Your Honor, there were over 30 counts, and that was in 2000, but there's cause for additional concern.
Was he sentenced on that case?
He received a withhold and 6 years probation.
All right. And that probation has terminated, correct?
Yes, ma'am.
Okay. All right, any argument in response?
No, I understand the state's position. I'm not going to argue bond at this time. Wait till it gets in front of the judge.
All right.
Who is it assigned to, by the way?
It is currently,
If I may, Your Honor, it's because it's on an arrest warrant. When we're done with it today, and the clerk's office takes the paperwork back, they'll assign a case number to the judge.
okay, thank you.
All righty, thank you.
All right, sir, at this time, I'm going to order that you also respond to pretrial level 1 with GPS monitoring, engage with no digital devices. That includes computers, smartphones, any other digital device with internet access, and that you not have contact with any individuals under the age of 18 years old. Do you understand?
Yes.
All right, thank you, sir.
Okay, and just remember, do not talk to anyone.
Nathan Burke?
Mr. Burke is here, present. Judge at Maine, he's approaching.
Good morning, Mr. Burke. You're currently charged with 1 count of misdemeanor domestic battery. The court does find probable cause. Does he have any priors?
Checking that right now.
I would point out, Judge, this appears to be a mutual combat scenario, as his brother, who is the next person on our docket,
Found
was also
PCS to
arrested.
both.
So,
Your Honor, his criminal history, criminal mischief in 2016 and 2015, disrupting school function 2014, loitering and prowling 2012.
All right, sir, the court at this time will grant you pretrial release with GPS monitoring. You're to have a psychiatric evaluation within 48 hours of this court's order. Do you understand?
Yes, ma'am.
All right, and where are you currently living, sir?
I stay with my mom.
Is your brother still living at that house?
Yes.
All right, I'm going to order that you have no harmful contact with your brother. If the police get called out to that home again, you're going to be in violation of this court's order. Do you understand?
Yes, ma'am.
All right. No harmful contact, yes. Yes, please, thank you.
Judge, if I heard correctly, you did you place him on an ankle monitor?
GPS, yes.
Judge, I believe there's a cost associated with it, $5 per day. He is on disability. Would Your Honor consider waiving the cost of supervision on that?
Any objection?
No.
That's fine with me.
Thank you.
All right, Lawrence Knight.
Mr. Knight is here, present, Judge, and he declined the services of public defender. He's approaching, Judge. Hold on one moment. Here he is. Good morning, Your Honor.
Good morning. Mr. Knight, can you afford your own lawyer?
No, ma'am. I'm right now. I'm on unemployment. My teacher assistant position at Lauderhill Paul Turner Elementary doesn't carry over the summer. So I really don't have the
Understood,
financial...
sir. Understood. And the court is prepared to appoint the Public Defender's Office to represent you for the purposes of this morning's hearing. It's my understanding you don't want that. Is that correct?
Yes, ma'am, because I wanted to address you directly, if that's okay with you.
You're still entitled to address me directly upon the advice of counsel with their assistants next to you. You want to do that?
No, ma'am.
All right. At this time, sir, are you freely, voluntarily, and knowingly waiving your right to counsel for the purposes of today's hearing?
Yes, ma'am.
All right. Has anyone forced you or coerced you to make that decision?
No, ma'am.
All right, sir, you're currently being charged with 1 count of domestic battery. At this time, the court does find probable cause. The court is prepared at this time to grant you a $1,200 bond or pretrial release if there's limited or no criminal record. Do we have anything?
Resisting Without Violence, 2012 with death in 05.
All right, the court is inclined to grant you pretrial release as well as for your brother. Is that what you want to do?
What is pretrial release, ma'am?
It means you don't have to post a monetary bond. You can go ahead and report to an officer who will make sure you're abiding by the conditions of your release.
What other options do I have, ma'am?
The option is to bond out at the amount of $1,200.
No, we'll do the pretrial, ma'am.
All right, pretrial release, level 2 GPS monitoring, no harmful contact with the listed victim in the case.
That's what ankle monitor? But I mean, she's not, excuse me, ma'am?
Yes.
Ma'am, in regards to this case, ma'am, the domestic battery.
Sir, I'm gonna advise you at this point in time that anything you say in court can and will be used against you in the future proceedings.
I'm fine with that, ma'am. The issue, I'm fine with that, ma'am.
All right, go ahead.
I know I look like a fool in front of everybody, but I just want the truth to come out, ma'am, because the information that was given to you is not the complete truth. My brother has a mental health issue.
I have that information, sir. I want to make sure he gets the help he needs, okay?
Absolutely, ma'am. Because of his mental health issue, he's been destroying property at the house. So when he was there with the altercation, he was actually trespassing at that time because he's already been evicted.
He doesn't live there currently?
No, ma'am. There was no physical altercation between us at all. I don't understand why I was arrested.
Who owns that house, sir?
The house is under my name. I'm the caregiver of my mother. And he just comes there because, you know, it's our mother. He visits her and comes there.
Where does he sleep otherwise?
I don't know.
All right. What's his name? His brother. All right. Is Mr. Burke still with us?
He's in the cell, as Representative said.
All right. As to Mr. Burke, I'm going to order no contact with the victim. Sir, you can continue to live in the home. Your brother is going to have a no contact order and no return to the home.
Yes, ma'am.
All right. At this time, you are entitled to your defenses. You'll be assigned to a division judge who will address those with you, okay?
Yes, ma'am. Thank you.
I'm sorry? Mr. Knight, you wanted to opt for pretrial, correct?
I mean, that's the only option I have of getting out because I don't have $1,200, ma'am. I don't. I've been in jail for 24 hours, and I had no physical contact with him at all.
Understood, sir. I'll go ahead and grant your pretrial release. No GPS for him. Standard pretrial release. No contact with the victim, Mr. Nathan Burke.
Yes, ma'am. Thank you, ma'am.
Your Honor, our Spanish interpreter is here.
All right. Who's in need of the services of the Spanish interpreter?
Someone in the main jail. I'm not exactly sure who.
Judge, I believe on page 17, and his name is Mr. Jorge Trujillo.
Morning, Your Honor.
Good morning.
Your Honor, Spanish interpreter for the record.
And I'm sorry, who are you here on?
Page 17, it should be in the middle of your stack of paperwork.
Thank you. Is he the only one?
I haven't gotten past 17, so I'm going to make an
Okay,
announcement in a second. Judge,
Jorge
before you go
Trujillo.
any for- Judge,
We would be
before you go
waiving
any
formal
further,
reading of the
waiving
charges.
formal reading of the charges.
Vamos a obviar la lectura de los cargos.
All right, sir, you are before me on 3 charges this morning. The court is finding probable cause as to all 3. All 3 have no bond holds.
No tiene fianza y se determina que hay indicios de culpabilidad por esos 3 cargos.
You understand, sir?
¿Entiende, señor?
Sí, pero...
All right, thank you, sir.
Your Honor,
Gracias, señor.
I do not believe, in reference to count 2, that it should be a no bond hold. I think that per statute he's entitled to bond on that case.
Tiene derecho a fianza en ese caso por el cargo número 2.
Married, single, with a divorce. One more time.
All right, these are new filed KPSs?
this is based on an arrest warrant, Your Honor.
All right, any prior record?
He does, Your Honor.
Sir, just for your edification, he does have a no bond immigration hold.
Está solicitado por inmigración.
If I could just have one moment.
Go ahead.
Michelle, you have him on a GPS, right? You have him on a GPS, right? Your Honor, he has a pending case. I'm not certain that these allegations violate his release conditions. He was released June 25th.
Junio 25, sí que no creo en esa alegación.
And it looks like these incident dates are from May 14th.
Este es mayo 14, parece que tiene fecha ese incidente.
Wasn't seeking revocation. I just wanted to confirm that you have him on.
Queremos confirmar si tiene la fianza.
All right.
Judge,
What's the nature of the open case?
La naturaleza de los cargos. Libertad provisional con el GPS. En otros cargos que no están relacionados. Thank you.
He's been charged with, well, I don't know if the public defender wants us to go to sidebar because they wish to waive reading on the...
Okay, I'm hearing that he's been charged with similar charges previously, yes?
Similares se van a omitir la lectura de esos cargos.
Not similar, but not exactly. They're not, digital, issues with digital imagery.
Son similares, pero esto tiene que ver con una imagen digital.
If you'd like, Your Honor, I can provide the court and Mr. Reed with a copy of the information.
I think I have an idea.
Del escrito a su señoría.
All right, sir, at this time, the court, having found probable cause as to count 1, I'll go ahead and set a bond of $250,000. On count 2, I'll set a bond of $250,000. On count 3, you have a no bond immigration hold. You understand?
Cargo 1, señor, el cargo 2, ya se han dado los indicios de culpabilidad. El cargo 1 y 2 han impuesto una fianza de $250,000. En el segundo, $250,000. En el tercero, va a tener la retención de inmigración.
I'm also going to order that you have no contact with any persons under the age of 18.
Y también voy a ordenar que tenga contacto con una persona menor de 18 años.
Sí, pero...
And that you not make use of any digital devices
Y se le prohíbe el uso de dispositivos digitales
while your cases are pending. You understand?
mientras sus casos están pendientes. ¿Entiende?
Sí, señor.
Yes, sir.
All right, thank you, sir.
Gracias, señor.
Judge, if I may.
Go ahead.
¿Permite, su señoría?
Currently, the $500,000 bond is something that Mr. Trujillo is simply not going to be able to afford.
Trujillo no puede pagar eso de $500,000. No puede pagar esa
When he was
cantidad.
out of custody, I do realize there's an immigration hold, but when he was out of custody, he worked in construction making approximately $140 per day.
Y trabaja en construcción, había salido de custodia, trabajaba aproximadamente $140 por el día de trabajo de construcción.
His aunt, who he lives with, works at a manufacturing plant, I believe, making curtains, and she makes approximately $10 an hour.
Vive y la compañera gana aproximadamente $10 la hora en una fábrica de manufacturera de cortinas.
So just financially, I just wanted to point out that he's not going to be able to afford a $500,000 bond. So we'd be asking you to consider his financial resources and impose a reasonable bond on these allegations. We'd be asking you to consider $50,000 bond on each count.
Pedimos que la juez considere, ya que él no va a pagar esa cantidad de $500,000, si la juez puede considerar que reduzcan la fianza de $50,000 por cada uno de los cargos.
All right, at this time, the court has considered the nature of the offenses, the safety of the community, as well as the defendant's financial circumstances,
Entonces, la naturaleza de los cargos, la seguridad de la sociedad, de la comunidad,
to include the other charges that he's currently on pretrial release for,
uno de otros cargos por los cuales él está ya bajo libertad provisional previamente,
and the court is deeming this to be a reasonable bond.
y la Corte
Thank you,
determina
sir.
que esta es una fianza razonable. Gracias, señor.
Yes, sir.
Mr. Christopher Vinson?
Oh, Judge, there is one more gentleman that raised their hand that's going to require a Spanish interpreter.
Okay, his name?
Page 29 of the docket, and his name is Orlando Cuervo Martinez. Señor Cuervo Martinez.
Where is he on the court's docket?
It's a reset. It should.
Está reprogramado.
It's at the end.
Martinez?
Cuervo Martinez.
Cuervo
Cuervo Martinez? Fifth?
5 contando de abajo, parte de abajo.
I don't have him fifth.
Cuervo Martínez, Orlando.
All right, good morning, Mr. Cuervo Martinez.
Buenos días, señor Cuervo Martínez.
You're currently before the court on one count of petty theft,
Usted está aquí ante la corte por un cargo de hurto de menor cuantía,
as well as an immigration hold.
al igual que una retención de solicitud de inmigración.
The court is finding probable cause. You have a $750 bond on the petty theft.
La corte halla índice de culpabilidad e impone una fianza de $750 por el hurto de menor cuantía.
And your immigration hold is a no bond hold.
Y la retención de inmigración a solicitud no otorga fianza.
All right, thank you, sir.
Gracias, señor. Should interpret make an announcement, Your Honor?
Please.
Alguien más necesita el intérprete de español, levanta la mano y da su apellido.
One here at Maine, Judge, requires a Spanish interpreter. I don't know if the other facilities.
All right, thank you. All right, let me just get you to announce for the other facilities.
Yes, Your Honor.
All right, Paul Ryan. Go ahead.
¿Intérprete de español se necesita? ¿Español?
Conti.
We good?
North Broward.
No, Your Honor.
All right. Thank you so much, sir. Have a good day. Christopher Vinson.
He's here at Maine.
Good morning, Mr. Vinson. You're currently being charged with one count of domestic battery. The court is finding probable cause. Any prior record?
I show no record, Your Honor.
All right, at this time, sir, the court will grant you a $2,500 bond. Does he qualify for pretrial?
And Your Honor, even with no history, based on the allegation that there was a threat to kill, I am requesting that some monetary bond be imposed.
All right, sir, at this time, the court's imposing a $2,500 bond, ordering you to have no contact with the listed victim in the case, Mr. Kelvin Peacocks. Are the two of you currently living together?
Judge.
Okay.
Judge, I'm going to be requesting that you reconsider the $2,500 to a $1,000 bond. As you heard, he has no prior record. He's here on a misdemeanor offense. He's 21 years old, been here his whole entire life. At this time, he's unemployed. He just lost his job. He was working at GNC, making about $8.50 an hour. He lives separate and apart from the alleged victim. I believe the alleged victim is his stepfather. He lives in Cooper City. Him and his roommate, they rent a house. His portion of the rent is about $600 per month. He's going to be contacting his girlfriend to help post his monetary bond. His girlfriend goes to school at Broward College, and she works at a fast food restaurant. So $2,500 is going to be out of their reach. Judge, I'd ask you to consider, once again, a $1,000 bond on this misdemeanor offense.
All right, if he wants reduction to $1,000, I am inclined to put him on pretrial release with GPS monitoring to ensure no contact and compliance. Any objection?
Judge, he wishes to accept the court's, suggestion as far as $1,000 with pretrial.
All right, $1,000 bond, pretrial release, level 2 with GPS monitoring, no victim contact.
And would you consider waiving the costs of $5 a day because he's not working at this time?
I will.
Thank you.
All right, Mr. Ricardo Jimenez.
Mr. Jimenez, come on up, please.
Good morning, Mr. Jimenez. You currently have an out-of-state hold for a felony escape charge. The court is finding probable cause. You have no bond, all right?
Good luck, sir. You'll be taking that tradition court, which meets on Tuesdays and Thursdays, okay?
Ms. Francesca Vizcarrando.
Ms. Vizcarrando is approaching. Judge, come on up, ma'am.
Good morning, Ms. Vizcarrando. You have currently 1 count of petty theft. You have a $25 bond on that, and you have a misdemeanor capias for another petty theft. You have a $500 bond on that. You'll see your division judge if you can't bond out, okay?
Okay.
Good luck, ma'am.
Dalal Abu Jabbar.
Good morning, Judge. Stephen Shade on behalf of Ms. Abu Jabbar.
Good morning.
No prior, Your Honor.
Thank you.
Judge, these cases come out of Hollywood. The city attorney for the city of Hollywood and I have spoken about these matters, not these ones specifically, but of these type, and they have no problem with time served.
All right, ma'am. Can you see your attorney here?
Yes, ma'am.
All right. You currently have 2 warrant cases out of the city, 1 for trespass and 1 for loitering and prostitution. Are you interested in resolving those cases today?
Yes, ma'am.
All right. In the event you're not interested, you have a $25 bond on count 1, $100 bond on count 2. Any prior criminal history?
Yes, Judge. 2017, possession of cocaine. 2016, dealing with stolen property. 2015, possession of oxycodone. Theft 09, oxycodone 08, grand theft 08. It goes on from there.
All right, ma'am. If you choose to resolve these today, I will adjudicate you guilty. Give you time served.
Yes,
Is that what you want to do?
Yes, ma'am.
All right. Raise your right hand for me. You swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am.
Ma'am, how far did you go in school?
The 12th grade?
Read and write English?
Yes, ma'am.
How old are you?
I'll be 36 on the 16th.
Are you currently under the influence of any drugs, alcohol, or prescription medication?
No, ma'am.
Are you currently under a doctor's care for anything?
No.
Have you ever been diagnosed with a mental illness?
No.
Okay, I note your attorney is present in court here to represent you today. You satisfied with his services?
Yes, ma'am.
And how do you wish to plead to these charges?
No contest.
No contest.
Has anyone forced you, coerced you, threatened you in any way to get you to enter a no contest plea to these charges?
No, ma'am.
All right, you understand if you're not a U.S. citizen, you will be deported as a result of the adjudication?
Yes, ma'am.
All right, at this time, ma'am, the court will accept your no contest plea as freely, knowingly, and voluntarily entered, adjudicate you guilty, sentence you to time served on both counts.
Thank you.
Good luck to you, ma'am. You have 30 days to appeal.
Judge, are we able to jump to another one on page 8? The name is Edward Christie. It's at the top of
Christie?
the docket. Correct. Christie. It shows Lighthouse Point on the docket, Judge. It's actually coming out of Deerfield Beach. And I'd ask that they
All
be
right.
time served as well.
We have Mr. Christie.
Thanks. How'd you know? Okay. I'll text him right now.
All right, thank you.
Okay, I was gonna text Mike. Oh,
We have Mr. Edward Christie.
Judge should be in main jail.
He's approaching, Judge. He's here at main jail.
Thank you. All right, good morning, Mr. Christie. You're currently here for 2 capious charges, both misdemeanors, 1 city charge for littering, 1 open container charge. The court is finding probable cause on both charges. You have $50 bonds on both charges. An attorney is here to represent you. If you're interested in resolving both cases, I'll adjudicate you guilty, give you time served. Is that what you want to do?
Yes, ma'am.
All right, raise your right hand for me. Do you solemnly swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am.
Sir, how old are you?
56.
How far did you go in school?
You're in college.
Read and write English?
Yes, ma'am.
You currently under the influence of any drugs, alcohol, or prescription medication?
No, ma'am.
You currently under a doctor's care for anything?
No, ma'am.
Is there anything affecting your ability to understand what's going on here today?
No, ma'am.
All right, and I note that Mr. Shade is here to represent you this morning.
Judge, if I could interject real quickly.
Go ahead.
Mr. Linder had just explained to me that he's being held on a felony matter, and obviously he's in a red jumpsuit. I'd ask that we just set this to the division.
Absolutely, sir. Upon your attorney's advice, it's my understanding that it's in your best interest to set this over for division, as there are other charges in your future. You understand?
Yes.
All right, the court is finding probable cause. You'll see your division judge. $50 on each count.
Thank you, Judge. And Judge, if we could go one more, then I'm going to run over to the felony side.
All right.
Gentleman's name is Douglas Farmer. He's on page 9. It shows Pompano Beach, Judge, but it's actually out of Deerfield Beach. And I said to
Okay,
be
have you
time
had
served.
contact with Deerfield?
He's approaching, Judge. Mr. Farmer's here. There's your attorney, Mr. Shade.
Yes, Judge.
All right, good morning, Mr. Farmer. You're here on 1 capious for unlawful assembly. The court is finding probable cause. You have a $50 bond on that count. Your attorney is here to represent you this morning, is indicating to me that you're interested in pleading no contest and receiving a time-served sentence. Is that correct?
Yes, Your Honor.
All right, sir, raise your right hand. Do you solemnly swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
How old are you, sir?
I'm 54.
How far did you go in school?
I graduated high school.
Read and write English?
Pardon me?
Read and write English?
Yes.
Are you currently under the influence of any drugs, alcohol, or prescription medication?
No.
Are you currently under a doctor's care for anything?
No.
Have you ever been diagnosed with a mental illness?
No.
And I know Mr. Shade is here to represent you this morning for these purposes. Are you satisfied with his services?
Yes, Your Honor.
And it's my understanding you wish to plead no contest to this charge. Has anyone forced you, coerced you, or threatened you to do so?
No.
You doing so of your own free will?
Yes.
You understand these charges could result in deportation?
Yes.
All right, at this time, the court finds that Mr. Farmer's freely, voluntarily, and knowingly entering his plea of no contest to 1 count of unlawful assembly. Court will accept his no contest plea, adjudicate him time served.
Thank you, Judge. Have a wonderful day.
You too, thank you. Kenya Coles?
It's just an out-of-county hold. So it's really not for magistrate.
Stephanie Jolly?
Judge, did you do Ms. Coles?
She was removed.
They're both in North Broward.
Ms. Coles is at North Broward?
Kenya Coles, yes, she's in North Broward. And she wants to resolve this case today if possible, Judge. An out-of-county hold?
Good morning, Ms. Coles.
Oh, it's
You
an
have been
out-of-county hold.
removed from the magistrate docket this morning. You have an out-of-county hold, okay?
Okay.
So they'll come and get you.
Thank you.
Stephanie Jolly?
North Broward, Judge. Ms. Jolly would like to resolve this matter if possible today.
Good morning, Ms. Jolly. You're here for one capious count of a misdemeanor traffic offense, failure to obey a police officer. You have a $250 bond on that count. The court is finding probable cause. It's my understanding you wish to resolve that case?
Yes, please.
Any prior record?
One moment, Judge. Only thing I see is excuse me, another failure to comply with order from 2017.
When Ms. Jolly resolved that case, Judge, she thought that this case had also been resolved at that time.
Gotcha. All right, ma'am, if you're interested in resolving the case today, I'm inclined to adjudicate you guilty, give you time served. Is that what you want to do?
Yes, ma'am.
You feeling okay this morning?
Yeah.
All right. Raise your right hand for me. Do you solemnly swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
All right, ma'am. How old are you?
31.
How far did you go in school?
10th grade.
Read and write English?
Yes.
Currently under the influence of any drugs, alcohol, or prescription medication?
No, ma'am.
Are you currently under a doctor's care for anything?
No.
Have you ever been diagnosed with a mental illness?
Depression.
All right. Is that affecting your ability to understand what's going on here today?
No, ma'am.
All right. And I note that you are being represented by the Public Defender's Office for the purpose of this hearing today. Are you satisfied with their services?
Yes.
All right. And it's my understanding you wish to plead no contest to one count of failure to obey a police officer. Is that right?
Yes, ma'am.
Has anyone forced you, coerced you, threatened you in any way to get you to enter that no contest plea?
No, ma'am.
You doing so of your own free will?
Yep.
You understand the charge could result in deportation?
Yes.
All right. At this time, the court does find that Ms. Jolly is entering her plea freely, knowingly, and voluntarily. The court is accepting her no contest plea to one count of failure to obey a police officer, adjudicating her guilty. Time served. Thank you, ma'am. Good luck to you. 30 days to appeal. Jessica Schaefer.
North Broward.
Good morning, Ms. Schaefer. You're currently before the court on one count of dealing in stolen property, one count of false ownership to pawn shop, one felony violation of probation. I'm sorry, 2 counts of felony violation of probation. The court does find probable cause as to all counts. At this time, you have a $3,500 bond on count 1, $1,000 bond on count 2, counts 3 and 4, violation of probations or no bond holds.
Yes, ma'am.
Good luck to you, ma'am.
Thank you.
Good luck, Jessica.
Thank you.
Camila Copabea.
She's your president, main judge.
Thank you. Did you get your phone? All right, good morning, ma'am. You're here on one count of felony grand theft. You have a $1,000 bond on that count. The court is finding probable cause. You'll see your division judge. Thank you, ma'am.
Judge, if I may.
Go ahead.
Ms. Correa, my understanding is this is her first arrest ever in her life. She's 19 years old. At this time, she's currently working. She's a hostess at a restaurant called Tea Spice. She's been there for about 6 months. She lives right now with her boyfriend in Hollywood. She gave me the phone number of her boyfriend, and I'm going to intend on calling her after court. But considering this is a nonviolent offense, and if the state can't confirm this is her first arrest ever, and there's a presumption to be released on non-monetary conditions, Judge, I'd ask you to consider releasing Ms. Copevilla on a straight ROR.
All right,
She has no
state's
criminal
position.
history. I'm fine with that, Judge.
All right.
And I apologize that the court ordered it. I just asked that there be no return to this TJ Maxx.
All right.
You
And
can't go back. Judge can instruct.
ma'am, you understand that if I release you on your own recognizance, it's going to be your responsibility to get yourself to court for your future hearings. You understand?
Yes.
Does the court have your correct address?
Yes.
That's 2303 North 20th, is that right?
No.
No? Okay, then tell the court what's your correct address.
Let me write.
And this is Scott.
20.
All right, ma'am, when did you
Judge,
move?
it's 15.
When did you move from that address?
When?
When did you?
About 1 month ago.
A month ago?
Yeah.
All right, ma'am, the court will put you on standard pretrial release. It's your responsibility to get yourself to court and to report to pretrial, all right? Upon verification of your new home address, okay?
Judge?
Yes.
If I may? At this time, Your Honor's not going to do a straight R, but rather put her on pretrial release with supervision.
That's right, standard pretrial, call in.
Judge, in that case, I'd be asking you then to leave the standard bond alone. I'm going to contact her boyfriend. Releasing her on pretrial release, my opinion is it's non-monetary. And no, it is a monetary condition because she has to actually come and report to pretrial. There's an expense associated with it. Parking at the parking garage costs about $8 an hour. So respectfully, then I'd ask you to just leave the standard bond in place, and I'd call her boyfriend and bond her out.
I love the argument, super original, but it is a non-monetary condition. I will impose standard pretrial. In the alternative, she can pay the $1,000 bond, okay?
$1,000 bond, okay. I'll call your boyfriend right after court.
Yeah, Hector, her boyfriend's here. He says he's going to be able to bond her out.
Beautiful.
Hector? Good man.
Yes.
All right.
Okay,
Faye
so your boyfriend
Chengdu?
bonded, Judge. Thank you.
Shendra Edwards?
She's approaching, Judge.
Thank you. You still need to see? Even if it wasn't addressed? Good morning, Ms. Edwards. You're currently before the court on a total of 4 counts: misuse of temporary tag, driving on a suspended license, open container, and probation violation for a felony. The court is finding probable cause on count 1. You have a $100 bond.
Sheila? Do you know what state this probation is?
Count 2, $100 bond. Count 3 is not for magistrates. Count 4, there's a no bond hold. Good luck to you, ma'am.
Good luck, though. Sheila's on. Don't matter.
Robin Darville?
It's a medical reset, Your Honor, for tomorrow.
Thank you. Andrea Murray?
North Broward, I believe.
Still a medical reset, Judge.
Thank you. John Green?
Mr. Green is here at Main, Judge, and he is approaching.
Good morning, Your Honor.
Judge, he
Good
declined to
morning.
serve as a public defender.
I'm sorry?
Declined the service as a public defender.
Okay, thank you. Sir, you understand you are entitled to a lawyer today. If you can't afford one, the public defender's office is here to help you. You understand?
Yes.
And you don't want that today?
Yes.
You do want their help?
Yes.
He just changed his mind.
All right. All right, at this time, sir, you're before the court on 2 capious charges, both counts of trespass. There's $500 bonds on each count. Thank you, sir. The court is finding probable cause as to the capiouses. Go ahead.
In speaking with Mr. Green, he wishes to ask the court if you will consider resolving both counts today. For time spent.
I don't have the victim address. Mr. Linder, anything?
One moment, Your Honor.
They're reviewing the PC affidavit, and they're going to see if they go ahead and make you an offer or not today, okay? Hold on 1 moment.
Thank you.
Your Honor, I can look that up, but while I can tell you, it appears that Mr. Green has about multiple other pending trespasses before, another one before Judge Evans, 2 before Judge Hurley. Between this year and last year, it looks like he has resolved 15 additional trespasses.
Okay, sir, if you want to resolve your case today, I'll adjudicate you guilty, sentence you to 20 days Broward County Jail. Is that what you want to do?
Let me explain that to him.
Okay.
Judge, in speaking Mr. Green, he advised me he wishes to accept the court's offer, Judge.
All right, Mr. Green, raise your right hand for me.
Can't release me.
The judge said no. She made you an offer of 20 days. Now, you don't have to accept it. Is that what you want to do?
Yes. You just want
All right, Mr. Green, do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right, how old are you, sir?
50.
How far did you go in school? How far did you go in school?
12th grade.
You read and write English?
Yes.
Are you currently under the influence of any drugs, alcohol, or prescription medication?
No.
Are you currently under a doctor's care for anything?
No.
Is there anything impeding your ability to understand what's going on here today?
No.
All right, and I note that you are being assisted by the Public Defender's Office. Are you satisfied with their services?
Yes.
And at this time, it's my understanding you wish to plead no contest to 2 counts of trespass. Is that right?
Yes.
Has anyone forced you, coerced you, or threatened you in any way to get you to enter your no contest pleas?
No.
You understand these pleas could subject you to deportation?
Yes.
You understand that if you're ever charged with a sexually motivated, sexually violent offense, that these offenses could subject you to civil commitment?
Yes.
All right, and at this time, do you wish to enter your no contest pleas?
Yes.
All right, at this time, I find Mr. Green has knowingly, intelligently, voluntarily entered his pleas of no contest to case numbers 18991 MM20A and 18849 MM28. The court finds his pleas are knowing, intelligently, and voluntarily made. The court accepts his no contest plea, sentences Mr. Green to an adjudication, 20 days, Broward County Jail, to run concurrent on both cases. Thank you, sir. You have 30 days to appeal. I'm sorry? Credit time served, yes. Timothy Odom.
He's approaching, Judge. These are municipal ordinance cases.
All right, good morning, Mr. Odom. You're before the court on 3 city cases. No OSHA safety vests, no roadway safety course, and panhandling. You understand you're entitled to a lawyer on these cases?
Yes, ma'am.
All right. At this time, do you wish to have the services of a lawyer provided for you?
Yes, ma'am.
I'm sorry, sir. What are you here on?
Yes, Your Honor.
Page 26, Your Honor.
I'm sorry?
Kingston Duke is on page 26.
Okay. Sir, can you afford your own attorney?
No.
And Mr. Reedy, remind me, what is the PD's office position on city cases at this point in time?
We cannot represent Mr. Odom. The city of Pompano is responsible for providing him with counsel. They have not done so. Not only that, but they house their city ordinance violators in the Broward County Jail without paying for it. They don't pay for counsel for these people. There's nothing that we can do to help them, and it's not a very positive situation at all.
All right, sir, I can reset your case for tomorrow and have the city bring in a lawyer for you, all right? Or if you're inclined to resolve your case today, I am inclined to adjudicate you, give you time served to resolve the matters. What do you want to do?
Excellent. Today, adjudicate, time served.
Okay, you understand you are entitled to the assistance of counsel to help you make that decision. Are you waiving that right today?
Yeah, I guess I am. Yes, ma'am.
All right, has anyone forced you, coerced you, threatened you in any way to get you to waive your right to counsel?
No, ma'am.
Are you doing so of your own free will?
Yes, Your Honor.
All right, sir. Raise your right hand. Do you solemnly swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
How old are you?
51.
How far did you go in school?
High school graduate.
Currently reading and writing English?
Yes, ma'am.
Are you currently under the influence of any drugs, alcohol, or prescription medication?
No, ma'am.
Are you currently under a doctor's care for anything?
No, ma'am.
Have you ever been diagnosed with a mental illness?
Yes, ma'am.
And what's the nature of the illness?
Depression.
Is that affecting your ability to understand me today?
No, ma'am.
All right, and I note that you've previously waived your right to counsel. Is that still what you want to do?
Yes, ma'am.
All right,
Yes,
and
Your Honor.
how do you wish to plead to these 3 charges?
Can I plead guilty with time served?
Or you have the option of pleading guilty or no contest. Which do you want to do?
No contest.
All right. At this time, sir, has anyone forced you, coerced you, threatened you in any way to get you to enter your no contest pleas to these 3 city cases?
No, Your Honor.
All right, at this time, sir, I do find that your pleas are knowingly, intelligently, voluntarily entered. I will accept your no contest pleas as to all 3 counts, adjudicate you guilty, sentence you to time served.
Stop talking.
Good luck to you, sir. You have 30 days to appeal.
Thank you, Your Honor.
Stop talking.
Rafael de Jesus Nunez.
Mr. Bonded, De Jesus Nunez, bonded, Judge.
Bonded. Thank you. William Hennigan.
Mr. Hannigan is approaching, Judge. He's here at Maine.
Good morning, Your Honor.
Good morning, sir. Sir, at this time, you're before the court on 2 misdemeanor capias cases. One for 1 count of trespass and a second for 1 count of trespass, both out of Central Courthouse. You have $500 bonds as to each case.
I'd like to try and resolve this if I can, please.
Sir, the court's not in a position to resolve your cases today. You'll see your division judge, okay?
Okay, the court didn't want to.
Kyle Rawson.
Mr. Rawson is here, Judge? At Maine?
Good morning, Mr. Rawson. You're currently before the court on 1 count of trespass. You have a $100 bond on that count. The court is finding probable cause.
Yes, ma'am. Judge, Mr. Rawson is asking me to inquire with the court if you would consider resolving his case today for, resolving it today, Judge.
Any prior record?
I don't see any.
No priors?
Looks like he has an open felony possession of basically 3 counts of fake driver's license
In Broward?
Dade County.
Okay. All right, sir, you're going to be able to stay away from the Solano community?
Yes, ma'am.
All right, if you want to resolve your case today, I'll go ahead and adjudicate you guilty, sentence you to time served, order that you not return to the Solano community. If you do return to the Solano community, that will be a violation of this court's order, as well as give rise to a new criminal offense. You understand?
Yes, ma'am.
You going to be able to do that?
Yes.
All right, sir, raise your right hand. Do you solemnly swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am.
How old are you, sir?
19.
How far did you go in school?
11th grade.
Read and write English?
Yes, ma'am.
Are you currently under the influence of any drugs, alcohol, or prescription medication?
No, ma'am.
Are you currently under a doctor's care for anything?
No.
Have you ever been diagnosed with a mental illness?
No, ma'am.
Is there anything standing in the way of your ability to understand what's going on here today?
No, ma'am.
I note you are being represented by the Public Defender's Office this morning. Are you satisfied with their services?
Yes.
And at this time, it's my understanding you wish to plead no contest to one count of trespass. Is that correct?
Yes, ma'am.
Has anyone forced you, coerced you, threatened you in any way to get you to enter that plea?
No, ma'am.
All right. Do you understand this plea will subject you to deportation if you're not a United States citizen?
Yes, ma'am.
All right, sir. At this time, I accept your no contest plea as knowingly, intelligently, voluntarily entered. I will go ahead and adjudicate you guilty, sentence you to time served. You are not to return to the Solano community. You understand?
Yes, ma'am.
All right. Thank you, sir. You have 30 days to appeal. Good luck to you, sir. Eddie Milliner.
Mr. Milliner, he's the judge, and this is a municipal ordinance case.
All right, good morning, Mr. Milliner. You're here before the court on 3 city counts: no safety vest, no roadway safety course, and panhandling. The court finds probable cause as to all 3. You understand you are entitled to the assistance of counsel if you can't afford your own lawyer. You understand?
Yes, ma'am.
Can you afford your own lawyer?
No, ma'am.
And at this time, do you wish to represent yourself, or do you wish for me to reset your case for the city to bring in a lawyer for you?
I represent myself. All right, just resolve it.
All right. Is anyone forcing you, coercing you, threatening you in any way to get you to waive your right to counsel today?
No, ma'am.
All right, sir. If you want to plead guilty or no contest to the charges, the court will adjudicate you guilty, sentence you to time served. Is that what you want to do?
Yes, Your Honor.
All right. Raise your right hand. Do you solemnly swear to affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am.
How old are you, sir?
29.
How far did you go in school?
12.
Read and write English?
Yes, ma'am.
Are you currently under the influence of any drugs, alcohol, or prescription medication?
No, ma'am.
Are you currently under a doctor's care for anything?
No, ma'am.
Have you ever been diagnosed with a mental illness?
No, ma'am.
And you've previously waived your right to counsel for the purposes of this hearing. Is that still what you want to do at this time?
Yes, ma'am.
All right. It's my understanding you wish to plead no contest to all 3 counts. Has anyone forced you, coerced you, or threatened you to do that today?
No, ma'am.
All right, sir. At this time, the court accepts your no contest pleas to all 3 counts. As knowingly, intelligently, and voluntarily entered, the court will adjudicate you guilty, sentence you to time served. You are not to return to the location of the panhandling, which was listed at 1000 West Atlantic Boulevard. You understand?
Yes, ma'am.
All right, thank you. Good luck to you, sir. 30 days to appeal.
All right.
To all 3, yes. Edwards?
She was on 6.
Edwards?
The problem was, Judge, when you read off the charges, what she was being held for, you just read off the charges, but you didn't make any changes. But then on the finding, it has $100 on the no charge count.
Oh, I didn't say it out loud? I
She-
apologize. I thought I did.
We just clarified, you said it at 100?
I did set it at 100, yes. You need her back? All right.
No.
All right, 10-day Morapi.
He's here present, and once again, this is a municipal ordinance case, Judge.
All right, good morning, Mr. Morapi. You're currently before the court on 2 municipal ordinance charges, one count of no safety vest and 1 count of panhandling. The court is finding probable cause. You have a $25 bond as to each count. At this point, sir, I'm willing to reset your case for tomorrow to allow the city to bring in a lawyer for you, or if you're inclined to resolve the case without a lawyer, we'll go through some more questions. I'm inclined to adjudicate you guilty, give you time served. Is that what you want to do?
Yeah, I'd like to resolve the case.
All right, sir, raise your right hand. How old are you, sir? I'm sorry, do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am.
How old are you, sir?
29.
How far did you go in school?
12th grade.
Read and write English?
Yes, ma'am.
Are you currently under the influence of any drugs, alcohol, or prescription medication?
No.
Are you currently under a doctor's care for anything?
No.
Have you ever been diagnosed with a mental illness?
No.
And I note that you are choosing to represent yourself this morning. Are you freely, voluntarily, and knowingly waiving your right to counsel?
Yes, ma'am.
Has anyone forced you, coerced you, or threatened you in any way to get you to do that?
No.
All right, it's my understanding you wish to plead no contest to 2 counts of city ordinance violations. Is that what you want to do?
Yes.
Has anyone forced you, coerced you, or threatened you in any way to get you to do that?
No.
Are you doing so of your own free will?
Yes, ma'am.
All right, sir, at this time, the court does find that you freely, voluntarily, and knowingly entered your pleas of no contest to 1 count of no safety vest, 1 count of panhandling. The court accepts your no contest pleas, sentences you on both counts to an adjudication, time served, and you are not to return to the listed address of the panhandling, 1000 West Atlantic Boulevard in Pompano Beach. You understand?
Yes, ma'am.
All right, thank you. Good luck to you, sir. 30 days to appeal.
All right, thank you.
Dennis Nadro.
Mr. Nadrell is here at Maine. Come on up, sir. He's approaching, Judge.
Thank you. All right, good morning, Mr. Nadro. You're currently being charged with 1 count of trespass. There's a capious amount on that charge in the amount of $1,000. The court does find probable cause on that charge.
Judge, at this time, we're going to be asking the court to consider resolving his case, and hopefully the court considers extending an offer and adjudication time served.
Your Honor, I can advise the court the documented offer from the assigned ASA in this case, and this was updated June 28th, was an offer of adjudication, court cost no return to the mobile gas station located at 901 West Sample Road in Deerfield.
All right, sir, I am inclined to offer you time served today. Is that what you want to do?
Yeah. I'd like to resolve it.
All right. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Do you swear to tell the truth? Can you hear the judge?
Yeah.
All right.
Okay, you can hear the judge, right?
That's a McDonald's.
Okay.
Sir, are you feeling okay this morning?
I just want to resolve it. Yeah.
He still appears to be under the influence of something, sir. I'm not going to accept his plea today, okay?
Understand. I don't. Judge, in that case, could we have this case reset for tomorrow?
Yes, 24-hour reset.
Thank you, Judge.
Paul Scott.
Mr. Scott is approaching, Judge.
Yes, ma'am.
Good morning, Mr. Scott. You're here on one count of petty theft. You have a $25 bond on that count. The court does find probable cause.
Judge, it's being Mr. Scott. He's going to be asking the court if Your Honor would consider releasing him ROR on this petty theft misdemeanor offense. He's 60 years old. Unfortunately, at this time, he is homeless. However, he does have a mailing address where he can get future court notices or correspondence. He was working, but unfortunately, as you could see, he suffered a hand injury which prevented him from working, so he's on medical leave. He's been out since March something. So at this time, there's nobody that can help post his monetary bond, and he can't post it. So that's why we're asking for an ROR, Judge.
Has all property been recovered to Publix?
It appears that way, looking at the probable cause affidavit, Judge. Looks like it was some lighters and some reading glasses.
All right, I'm not inclined to release him ROR in light of the lack of address, sir, but I am inclined to offer him time served if he wants to resolve the case today.
Let me talk to him, Judge.
And
Sure.
he does have a criminal history, Your Honor, just to advise the court.
Thank you.
All right. You understand you can fight it if you wanted to.
No, I don't need to.
All right.
It's fine with me.
Judge, he's asking, he wants to accept the court's offer.
All right, sir. You understand that an adjudication is a criminal conviction?
Yes, ma'am.
And you understand, in light of the nature of the charge in this case, the state can choose at a future date if you're charged again to charge you with a felony theft. Do you understand?
That's correct. Yes, ma'am, I do.
All right. Raise your right hand for me.
Mm-hmm.
You solemnly swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am.
How old are you, sir?
60.
How far did you go in school?
GED, high school.
Read and write English?
Yes, ma'am.
Are you currently under the influence of any drugs, alcohol, or prescription medication?
Not at all.
Are you currently under a doctor's care for anything?
Yeah, my wound, I'm in surgery, but it's resolved.
Okay, a physical wound?
What's that?
Physical wound.
Yeah, physical wound. It's
Okay.
It's in the final stages of skin grafts and stuff, so it's all good.
Have you ever been diagnosed with a mental illness?
No, ma'am.
Is there anything standing in the way of your ability to understand what's going on here today?
Nothing at all.
All right, and I note that you are being assisted by the Public Defender's Office this morning. Are you satisfied with their services?
Very much so.
All right.
Yes, ma'am.
And at this time, it's my understanding you wish to enter a no contest plea to one count of petty theft in the second degree. Is that correct?
Yes, ma'am.
Has anyone forced you, coerced you, threatened you in any way to get you to do that?
No, ma'am.
Are you doing so of your own free will?
Yes, ma'am. Yes, ma'am.
All right, sir, you understand that these charges could subject you to deportation?
Yes, ma'am.
All right, at this time, the court finds that Mr. Scott has knowingly, intelligently, voluntarily waived his rights. His entering his no contest plea. The court accepts his no contest plea as knowing, intelligently, and voluntarily entered. The court will adjudicate you guilty, sentence you to time served, and no return to the Publix located at 2511 East Atlantic Boulevard in Pompano. You understand?
Yes, my vehicle is parked in their lot, and they said I'd come back and get it after I get out. They've allowed me to do that, from what I understand. So I got to go, drive it off their property. They said they wouldn't tow it. I have a car parked in their parking lot, so that's the only thing I need to do.
All right, if I were you, sir, I'd contact law enforcement to get an escort to do that in light of the order, okay?
He said that, yes, that's what the officer told me, so that's what I'll do.
All right, thank you. So good luck to you. 30 days to appeal. Estefan Jones.
Bonded, Judge.
I have paper. Oh, it was already sent? All right. Good news to me. Jeremy Fudge. Oh, I'm sorry. Before we do that, there is someone in front of you. I'm sorry. What's your case?
Kinston Dugazon on page 26, Your Honor.
What's the last name again?
Dugazon, D-U-G-A-Z-O-N.
All right. All right, Mr. Dugazan, good morning. You are currently before the court on one count of possession with intent to sell or deliver cannabis and one count of possession of drug paraphernalia. The court is finding probable cause.
Judge, may I be heard on that?
Go ahead.
First off, for the record, Albert A.A. Cartenuto III on behalf of Mr. Dugazan. Judge, I would object to the court's finding of probable cause. I've spoken to the state. They agree that in the body of the probable cause affidavit, it does not establish probable cause to show that the crime that he's being charged with was actually committed by Mr. Dugazan. This apparently it stems out of a serving an eviction on July the 10th, and this takes place. Apparently, he wasn't arrested until almost 30 hours later. So there's no indication that Mr. Dugazan was present when officers came to serve an eviction on one Jeffrey Tyler, who is the tenant. Mr. Dugazan is only indicated as being present on the 11th of July when he was arrested at 6:51 p.m. The fact that there's mention made in the narrative that there was male clothing found in one of the master bedrooms, but the male clothing, could just as easily have belonged to the tenant, Mr. Jeffrey Tyler.
And Mr. Dugazan's credit cards.
That doesn't establish residence. Simply having a credit card or some paperwork in an apartment does not establish residence. If you'll notice on the booking sheet, Mr. Dugazan's permanent address is 6043 Southwest 35th Street, apartment 203, yet on the probable cause affidavit, they list his address as being that location where they were serving the eviction notice. So merely being there, and again, it's not clear that he was there on the 10th. There's mention made that there was a search warrant that was applied for, yet there's mention made in the narrative that the officers were authorized to conduct a search in the course of effecting the eviction of the tenants. Where Mr. Tyler is not clear. When Mr. Dugazan got there is not clear. There's a discrepancy in the so-called amount of cannabis that was found there. At this point, Judge, I would ask that no finding of probable cause be had and that Mr. Dugazan be released on his own recognizance.
All right, Mr. Linder, response?
Your Honor, I did speak with counsel, and while unless I missed it, I did agree with him that there's no probable cause, but we think there's no probable cause for very different reasons. I didn't see where the cannabis was field tested. But other than that, other than that, I don't agree with any of the other counsel's other arguments, because they also found his Broward County court paperwork there, not just his credit cards. I think there's enough to establish probable cause for possession of the cannabis. There's certainly evidence for probable cause of intent to sell. The one issue I need to perfect, I believe, is the issue that it was field tested.
Perhaps as to Mr. Tyler, Judge, but not as to Mr. Dugazan. Again, mere fact that paperwork was found there. There's nothing in the narrative that indicates that Mr. Dugazan ever made any statements to the officers acknowledging that he resided there.
All right, sir, I certainly understand your arguments. I think for the purpose of today's hearing, there is enough for a PC finding in that regard. However, I agree after Mr. Linder's statement there that there's no indication that the drugs found were actually field tested.
Correct, and
so in that regard,
notice the discrepancy in the amounts, Judge. On one location, they say 124 grams, and another location, they say 209 grams. So you've got a very big discrepancy there.
We do. However, for the purpose of the charge, it doesn't make a difference for today's purposes, but the court is not making a probable cause finding today in light of the lack of field test, 24 hours to perfect.
Thank you. Judge, is this going to be heard again tomorrow?
It is.
I have one problem with that. I am scheduled to be in federal court at 10 a.m. tomorrow for a detention hearing. So. Okay.
Is there anyone that could stand in for you, unless Mr. Linder wants to contact you upon receipt of an updated PC and
well, I can also tell you, well, I can obviously do that, but I can also tell counsel, I don't know if we start at 8:30. If you can possibly come here first, I can make sure we call the case.
I'll come here first, Judge.
All right. Just wave in my face and make me take you first.
All right. Absolutely. And that's over the finding of the court's intent to find probable cause over defense objection.
Of course.
Do not speak to anybody about your case, Mr. Dugazan.
I know. Count one.
Your Honor. Excuse me, this is Mr. Kingston. I was
Sir, go ahead and have a seat. Your counsel stepped out, okay?
Well, no, he's
I step out,
Oh,
yes,
I'm
Judge.
sorry.
your client wants to
Excuse me.
answer the question.
Yeah, do I have a bond, or Albert?
Right now, there's a bond, but they're not allowing you to bond out until tomorrow.
He can
Oh,
bond
you can go ahead and bond out, all right,
unless
yes.
he's contested.
I was asking for ROR, but you can go ahead and bond out.
Albert, could you speak to my wife and tell her to call the bondsman, please?
I will do that.
Okay,
All right, thank you. Judge, I'll be here tomorrow at 8:30.
Mr. Jeremy Fudge?
Yes, he's in the main jail, and Mr. Fudge is on page 11 of the docket.
Good morning, Mr. Fudge. You're being charged with 1 count of petty theft under a city capias. Court does find probable cause on that count.
Judge, it's a City of Fort Lauderdale municipal ordinance matter. It's a $1.25 petty theft. Items were returned to the store. I spoke to City Prosecutor Don Londeray, and he offered to withhold and court costs. I relayed the same to Mr. Fudge, and Mr. Fudge wants to accept and plead no contest.
No prior record?
I don't know if he has a prior record or not, Judge.
Does Mr. Fudge have any prior record?
One moment. Do you have his Your Honor, as far as Broward goes, a criminal mischief and resisting without violence last year, and another resisting without violence last year.
You received withholds on both of those?
I'm sorry, I didn't. Excuse me. Withholds on the criminal mischief and the resisting without violence. The second case of resisting without violence, he was adjudicated time served.
All right, sir, if he wants to resolve his case, I'll adjudicate him, give him time served today.
Judge, in light of it being a $1.25 charge, would the court withhold adjudication as the city has offered? Just don't want to put him at risk.
That's
Judge,
fine with, well, he's previously been adjudicated of another misdemeanor. I don't see the risk, but I have no problem with that.
Mr.
All right.
Fudge, I'm sorry. Go ahead, Judge.
Sir, it's my understanding you wish to plead no contest to 1 count of petty theft today?
Yes, Your Honor.
Is that your understanding?
Yes, Your Honor.
All right, if you can raise your right hand for me. Do you solemnly swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes.
How old are you, sir?
38.
How far did you go in school?
A few years of college.
Read and write English?
Yes.
Are you currently under the influence of any drugs, alcohol, or prescription medication?
Yes, Your Honor.
What are you on?
Hold on a second, Mr. Fudge. We don't want to have his medical record broadcasted to the world, Judge.
I'm asking him if he's under the influence of anything.
Well, you asked him what he's on. He was about to tell you what drugs he's taking, Judge. And I just didn't want him to say that.
Are those prescription medications, sir?
Yes, Your Honor.
All right. Are you currently under a doctor's care?
No, Your Honor. Yes, Your Honor. Not anything medical, though. It's mental illness.
All right. And what's the nature of your mental illness, sir?
Bipolar depression.
All right. And is that medication assisting you in understanding everything that's going on here today?
Yes, Your Honor.
Is there anything standing in the way of your ability to understand what's going on here today?
No, Your Honor.
All right. And I note that you are being represented by counsel here today. You satisfied with the services?
Yes.
Okay. And at this time, has anyone forced you, coerced you, threatened you in any way to get you to enter a no contest plea to 1 count of petty theft?
No.
You doing so of your own free will?
Yes.
All right, sir. At this time, the court accepts your no contest plea as freely, knowingly, and intelligently entered. The court at this time will adjudicate you guilty, sentence you, will withhold adjudication and order you to pay the mandatory court costs. You understand?
Yes, I do.
Further, you're not to return to the address of the victim location.
I have it as 3100 Southwest 12th Place in Fort Lauderdale. It's
Thank you.
a Food Plus.
All right, the Food Plus in Fort Lauderdale. You understand, sir?
Yes, I do.
All right, thank you, sir. Good luck to you. 30 days to appeal.
Judge, I have one more.
Go ahead.
It's Anthony Ziegler. He's maybe about 3 or 4 persons down from Mr. Fudge. Mr. Ziegler's in the main jail.
All right, good morning, Mr. Ziegler. You're currently being charged with capious count for 1 count of possession of paraphernalia. There's a $500 bond on that count. The court does find probable cause on the capious. What does he wish to do today?
Judge, he wants to resolve. I spoke to City Prosecutor Don Laundrie about this matter as well, and he offered an adjudication time, sir.
All right, and it's been a long time. Is this going to result in a 2-year DL suspension?
No, Judge, not this charge.
All right, sir. It's my understanding you wish to resolve your case today. Is that right?
Yes, ma'am.
All right, if you can raise your right hand for me. Do you solemnly swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am.
How old are you, sir?
40.
How far did you go in school?
College.
Read and write English?
Yes, ma'am.
Are you currently under the influence of any drugs, alcohol, or prescription medication?
No, ma'am.
Are you currently under a doctor's care for anything?
No, ma'am.
Is there anything standing in the way of your ability to understand what's going on here today?
No.
And I note you are being represented by counsel this morning. You satisfied with the services?
Yes.
And at this time, has anyone forced you, coerced you, threatened you in any way to get you to enter your no contest plea?
No.
Doing so of your own free will?
Yes, ma'am.
All right, sir, at this time, I do find that you freely, voluntarily, knowingly entered your plea of no contest to 1 count of possession of drug paraphernalia. I do accept your no contest plea. Sentence you to an adjudication, time served. You have 30 days to appeal. Good luck to you, sir.
Thank you.
Thank you. Thank you, Judge.
The VOP, this is a satellite VOP. We don't send satellite VOPs to the division, so he magistrate got to sign out.
Oh, I was told not to. Estefan Jones? Didn't you tell me it was deleted?
That was the one they had set in the office. They had set for tomorrow. To the division, so we don't go. It's not set for division. Okay. It has a date set for tomorrow.
Tomorrow?
Yeah, it's set for tomorrow.
Okay.
You want to bring it back up? No. Set tomorrow. Right. Yeah, see, they'll bring it back. Thank you.
Sure. All right, do we have Estefan Jones?
What page, Judge?
It's a recall, previously deleted Estefan Jones.
Judge, I'm
Page
being
10.
advised by the deputies that he was removed per confinement status.
All right.
Oh, he bonded? Oh, he bonded, Judge.
Bonded
Sorry.
on a VOP?
The $1,000 tax.
Oh, he did have a
according to the
$1,000 bond. Estefan Jones is what she gave me. Is that the right person?
He did post bond.
All right. Estefan Jones?
Yes, Judge.
Bonded, okay. All right, Coons McCall?
Mr. McCall, come on up, please. Please approach, Judge.
Good morning, Your Honor.
Good morning, Mr. McCall. You're charged with 1 count of trespass. You have a $25 bond on that count. The court does find probable cause. What does Mr. McCall want to do?
Judge, he wishes to ask the court if you would consider resolving his case today. Oh, you don't want to resolve? Oh, I'm sorry. I want to get that touched. Oh. Actually, Judge, he, my mistake. He
All right.
does not wish to resolve the case
Not
today.
a problem. You have a $25 bond on that charge. You'll see your division judge, sir.
Judge, would you consider ROR on this trespass offense?
Sir, where are you living currently?
In Northeast 7th Street, Fort Lauderdale, Florida, ma'am.
How long have you been living there?
For a couple of months now.
currently working, sir?
No, ma'am. I'm gonna get unemployment right now.
You collect monthly unemployment?
Yeah, I just started.
Okay, how much do you collect a month?
I haven't collected anything yet.
Okay.
Sign for addresses is a proposal.
Any prior failures to appear?
I don't see any prior failures to appear, Judge.
All right, sir, the court will grant you an ROR on 1 count of trespass. You understand it's going to be your responsibility to get yourself to court?
Yes, ma'am.
And if you don't do that, the judge will issue a warrant for your arrest. You understand?
Yes, ma'am.
All right, thank you, sir. Have a good day. Oscar Manson.
Mr. Manson, come on up, please.
All right, good morning, Mr. Manson. You're currently before the court on 1 count of disorderly intoxication, 1 count of resisting officer without violence, and 1 count of trespass. The court does find probable cause. You have a... I'm sorry, it's a no charge on count 1?
It's just the
no bond necessary
matter.
All right, ROR on count 1, $100 bond on count 2, $25 bond on count 3. All right, what does Mr. Manson want to do?
Nothing to add from the defense, Judge.
All right, thank you. Good luck to you, sir. Mr. Sasug Mabayo?
Mr. Mabayo? I'm sorry. He's approaching. How you doing?
What's the name of the company you work for?
All right, good morning, sir. You're currently charged with 1 count of disorderly intoxication. You have a $25 bond on that count. The court does find probable cause.
Judge, in speaking, Mr. Mabayo, Judge, we're going to be asking the court to consider releasing him in ROR. He does have a record, but I believe he's been clean now for about 2 years. Considering this is a misdemeanor offense, he has a place to reside. He lives in actually in Pompano, right? He lives in Pompano. He has a stable address. We'd be asking you to consider releasing him ROR.
All right, what's the state's position?
One moment, Your Honor. Your Honor, I'm fine with an ROR.
All right, sir, this court will release you on your own recognizance, order you not to return to the transit bus station located at 1257 North State Road 7 in Lauderhill. You understand?
Yes, ma'am.
All right, thank you, sir. Michael Parker.
Mr. Parker, come on up, please.
All right, good morning, Mr. Parker. You're currently being charged with 1 count of driving on a suspended license. You also have an open capias for driving on a suspended license. You have a $500 bond on the capias, a $100 bond on the new case. The court does find probable cause as to both. Thank you, sir. You'll see your division judge. Robert Burns.
Mr. Burns is approaching, Judge.
All right, good morning, Mr. Burns. You currently are before the court on 1 count of DUI above a .15 and 1 count of straight DUI capias. You have a $1,000 bond on each count. The court does find probable cause. You'll see your division judge, okay?
I'll call your girlfriend right after court so she can bond you out, sir.
Trent Shirley.
I believe that's
Medical reset.
There you go.
Thomas Moran,
Medical reset.
same with Patrick Wells.
Ryan, Wells a reset too?
Moran and Wells are both medical resets.
Michael Cade,
Medical reset.
Parrish George,
Medical reset.
Tyreek Johnson.
Conti, Your Honor.
I'm sorry?
He's in contact.
Conti.
Good morning, Mr. Johnson. You're currently before the court on 5 ad charge capiases for 3 burglaries, 1 count of petty theft. Sorry, 2 counts of petty theft. The court does find probable cause for each capias. You'll see your division judge, okay?
That's it? That's it, ma'am?
He needs bonds on the
these
3, 4, and 5.
Yes, Your Honor.
All right, sir, on your 18-7447 CF-10A case, that Berg conveyance bond amount will be set at $5,000. On 18-7446 CF-10A, Berg conveyance, the court will set a $5,000 bond on that capias. On 18-7446, the court will set a $5,000 bond. You have a $100 bond on the petty theft capias.
Can I speak to you about something? The one with the firearm? Not the firearm.
Sir, don't speak about the facts of your case today, sir, okay?
Yeah, I'm talking about the bond. I can't afford the first bond y'all gave me. It was $25,000.
Your Honor, the
Mr.
first
Johnson has a, I believe,
on counts 1 and 2.
Mr. Johnson, you have a no bond hold
Yes.
on count 1 and a $25,000 bond on count 2.
I can't afford the second one.
All right, your attorney will make a motion before your division judge to address it, okay?
All right.
Good luck to you, sir. Trevin Rembert.
Mr. Rembert is here at Main, Judge. He's approaching.
Your Honor, if we could put this on recall, I spoke with the detective who authored the probable cause affidavit, and he's going to be mailing me a supplemental report, but Hollywood PD's email is down at the moment.
All right. All right, Mr. Rembert, you're going to be on a brief recall, okay? Go ahead and have a seat for me. Anthony Johnson.
Medical reset, Judge.
Jason Mulderig.
He's here at Main.
Good morning, Mr. Mulderig. You're currently before the court on 3 counts, 1 petty theft, 1 violation of probation felony, and a 2nd count of violation of probation felony. The court does find probable cause as to all 3. You have no bonds on the felony VOPs. You have a $25 bond on the petty theft. Good luck to you, sir. Kenneth Benjamin.
Your trial, John.
Good morning, Mr. Benjamin. You're currently before the court on 1 count of possession of cannabis, 1 count of possession of cocaine. Court does find probable cause as to both counts. Court sets $100.
Judge, if I may be heard.
Go ahead.
On the probable cause as to the 2nd count, my reading of the probable cause affidavit indicates that the cocaine was allegedly found in the console area of the car in which Mr. Benjamin was a passenger. I would argue to the court that that is a joint possession argument for the state at best, and that there is no probable cause to hold Mr. Benjamin for the possession of cocaine charge. There's no indication in the report that Mr. Benjamin ever exercised any control or dominion over that cocaine. It's not his car. It's not his console. It's not clear from the report whether the console was closed and the items were not readily available to be seen from the outside of the car or from the inside of the car. So I would argue there is no probable cause to hold Mr. Benjamin on that charge.
All right, and I don't see that the defendant made any statements. Mr. Linder, any response?
Your Honor, I request 24 hours.
Any objection?
Mr. Benjamin, can you make a $1,000 bond? I mean, I can call your brother.
I doubt it, but I don't think I can.
I have Mr. Benjamin's brother's phone number, Judge. I'll see what I can do about getting the bond together.
All right, the court.
We'll see you tomorrow.
The court will set a $100 bond on count 1. Your bond on count 2 is currently set at $1,000, sir. 24 hours to perfect.
Okay, thank you.
We'll see you tomorrow, sir. Count 1's $100. Count 2 is $1,000. Count 2, perfect. Sanjay Henry.
He's here, President Maine.
Good morning, Mr. Henry. You're currently before the court on 5 counts: possession of cannabis, possession of cocaine, possession of ecstasy, driving on a suspended license, and open containers not for magistrates. On count 1, you have a $100 bond. Count 2, $1,000 bond. Count 3, $1,000 bond. Count 4, $750 bond. The court does find probable cause. You'll see your division judge, okay?
Judge, in speaking with Mr. Henry, unfortunately at this time he is homeless, he's unemployed, he's financially indigent. Therefore, the monetary bonds associated with these nonviolent offenses is something that he cannot afford, and there's no one that from the outside that he can possibly contact. I'd ask you to consider releasing Mr. Henry on pretrial release.
And, Your Honor, Mr. Henry is currently out on a $1,000 bond for grand theft auto.
In Broward?
Yes.
What's the case number on that?
17-10412 CF10A.
When was he released on that case?
He posted his bond September 7th of last year.
All right, bad news, sir. At this time, the court is going to revoke your bond under case number 17-10412 CF10A. After a finding of probable cause, you violated the conditions of your bond by picking up these new law offenses. Motion for pretrial release is denied at this time. All right, good luck to you, sir. Davia Hankerson.
Mr. Hankerson is here at Maine. Judge is approaching.
All right, good morning, Mr. Hankerson. You're currently before the court on 1 count of petty theft. Excuse me, grand theft over $300. The court does find probable cause. You have a $1,000 bond on that count. Good luck to you, sir.
Good luck, sir.
Albert Williams.
Mr. Williams, come on up.
All right, good morning, Mr. Williams. As to count 1, possession with intent, the court is only seeing probable cause as to a straight possession. Mr. Linder?
No, I agree, Your Honor.
All right. You're currently before the court on 4 counts: possession of ecstasy, possession of cannabis, introducing contraband into a detention facility, and you have a no bond felony capias for possession of cocaine. You have a $2,500 bond as to count 1, a $100 bond as to count 2, a $1,000 bond on count 3, no bond on count 4. Good luck to you, sir. Daquan Hickston.
Mr. Hickson. Come on up, sir.
Good morning, sir. You're currently before the court on 1 count of strong arm robbery and 3 counts of pickup orders issued by the court. The court does find probable cause on all 4 counts. On count 1, the court will set a $5,000 bond. You have no bonds on the pickup order, sir. Good luck.
Considering Judge has no bond holds, we're deferring any argument to be made in front of his division judge.
Thank you, sir. Antonio Elise.
Mr. Elise, come on up, please.
Good morning, Mr. Elise. You're currently before the court on 5 counts, including 2 misdemeanor capias counts and 3 counts of burglary conveyance. The court does find probable cause on all 3 counts. Your traffic criminal, first count is a ROR capias. Count 2, you have a $1,000 bond on that count. On counts 3, 4, and 5, the court's setting $2,500 on each count. Good luck to you, sir.
Yes, ma'am. Yes, ma'am.
Armando Denise.
Mr. Denise? 23. Oh, confinement set, this is take on. Judge, I'm being advised that he's not on the, I guess he's not here. Confinement status.
It shouldn't have been for, Sheila, this shouldn't have been from first appearance, correct? Yeah, I think it was the leader from the docket, Judge.
All right, thank you. Kirby Janot.
Come on up, sir.
Good morning, Mr. Janot. You're currently before the court on 2 capias counts. 1 misdemeanor, you have a $1,000 bond on that. 1 felony, which you have a no bond hold. Good luck to you, sir. The court does find probable cause.
Good luck, sir.
John Marinello.
He's approaching, Judge.
Thank you.
Good morning.
Good morning, Mr. Marinello. You're currently before the court on 1 count, 1 felony possession of cannabis over 20 grams. The court does find probable cause. You have a $1,000 bond on that count. Good luck to you, sir.
Judge, we're going to be asking Your Honor to consider releasing Mr. Marinello a straight ROR. My understanding, this is his first arrest ever in his life. He's 20 years old. He's a registered voter here in Broward County. He is employed. He works at GM Signs. He's been there for about 2 years. He makes about $10 an hour. He's a graduate of Monarch High School, class of 2016. He is saving up to go to college at Valencia. So, Judge, at this time, he has strong ties to community. This is a nonviolent offense. I'd ask you to release him on straight ROR.
All right, at this time, the allegations include that the defendant admitted he paid $200 for the suspect cannabis. At this time, the court doesn't find a reason to lower the monetary bond. Good luck to you, sir. Miss Alicia Albin.
Mr. Albin, come on up, please.
Morning, Judge.
Good morning, Mr. Albin. At this time, you're before the court on 1 count of battery on a law enforcement officer, 1 count of possession of heroin, 1 count of resisting without violence, and 1 count of trespass. The court does find probable cause on all 4 counts. On count 1, the court will set a $5,000 bond. On count 1, a $1,000 bond. On count 2, a $1,000 bond. Count 3, a $100 bond. Count 4, a $25 bond. Good luck to you, sir.
And
Judge, sorry.
No, nothing on this case. You go ahead, please, Mr.
Mr. Albin is asking me to ask the court if you would consider releasing him on pretrial release. Judge, he is 28 years old, been living here for about a year and a half in South Florida. He works at People Ready. It's like a labor pool company. So whenever they have work for him, he gets paid by the day, and that's about $60 per day. Right now, he's living at Boynton Beach in a sober house located in Boynton Beach, Judge. There's no one that could post his monetary bond, so that's why he's asking to be released on pretrial release, Judge. And we'd also ask you to sign an order allowing us to photograph the injuries that Mr. Albin sustained as a result of this incident, Judge.
As to your second request, that's granted. What's the state's position on pretrial?
I have no objection pending verification of residence, Your Honor.
All right, where are you currently living, sir?
715 Mission Hill Road in Boynton Beach.
All right, sir, at this time, the court will keep the monetary bonds in place. In the alternative, the court will authorize pretrial release. You are not to return to the area of 2261 Northwest 4th Court in Pompano Beach. Pretrial release will be authorized upon verification of a stable home address, okay?
Thank you, Judge.
Yes, ma'am. Thank you.
Your Honor, when it pleases the court, we can go back to Trevin Rembert's case.
All right. Trevin Rembert.
And
All right, you have something for me?
Your Honor, I provided, Dante, did you give the supplement to the judge yet? I provided a supplement affidavit, Your Honor, from Detective Pontigo, just to clarify, because he mentions in his original PC that the witness identified photo 6, but it didn't clarify whose photo was photo 6. I wanted to make sure that that was clear.
Thank you. All right, good morning, Mr. Rembert. You're currently before the court on 1 capious count of burg dwelling. Does he have a record?
I'm checking that right now, Judge.
Thank you.
Your Honor, I'm showing 2 thefts out of Dade County in 2014.
Misdemeanor or felony?
Misdemeanor. Other than that, he also had a misdemeanor theft in 05 out of Dade and in 06 carrying concealed firearm out of Dade. Nothing further.
All right, sir, at this time, the court does find probable cause as to 1 count of burglary dwelling. The court will set a $5,000 bond. Order you not to return to the area of 5450 South State Road 7 in Hollywood. Good luck to you, sir.
All right, thanks. Good luck, sir.
Richard Walker.
Please approach.
Good morning, Mr. Walker. You're currently before the court on 1 count of petty theft and 2 counts of felony violation of probations. You have a $100 bond on count 1. No bond holds on counts 2 and 3. The court does find probable cause as to all 3. Good luck to you, sir. Derek Morgan.
Mr. Morgan, come on up, please.
Good morning, Mr. Morgan. You're currently before the court on 1 count of petty theft, 1 count of grand theft auto, 1 count of possession of cannabis, 1 count of driving on a suspended license. You have a seatbelt violation that's not for magistrates. The court does find probable cause as to count 1. We'll set a $100 bond. Count 2, you have a $1,000 bond. Count 3, a $100 bond. Count 4, $100 bond.
Your Honor, I just want to bring it to the court's attention. Mr. Morgan is out on bond right now on 2 separate grand theft autos. He was arrested June 24th of this year for grand theft auto and resisting without violence. He posted a $1,000 bond, was released June 25th. And he was arrested June 2nd of this year for grand theft auto, posted a $1,000 bond, was released the same day on June 2nd.
You have the case numbers?
I do. The 2 case numbers are 186550 CF10A and 187539 CF10A.
All right, sir, more bad news for you. At this time, the court has made a probable cause finding as to the new law violations, finds that you have violated the conditions of your pretrial release on case numbers 186550 CF10A and 187539 CF10A, and hereby revokes your bond as to those 2 cases. Good luck to you, sir. You'll see your division judges. Gabriel Drone.
Bonded.
Rajon Lewis.
Sir Lewis is here at me, and he is approaching.
Good morning, Mr. Lewis. You're currently before the court on one count of burg conveyance, a second count of burg conveyance, and one count of petty theft. The court does find probable cause as to all three, sets a $5,000 bond on counts 1 and 2, $25 bond on count 3. Good luck to you, sir.
Judge, if I can be heard.
Go ahead.
Speaking with Mr. Lewis, he's 18 years old. He's been living in our community his whole entire life. At this time, he is employed. He just started working at Walmart. He works the night shift. I've been there for 1 month, making about $12 an hour. At this time, he's going to be coming up this fall. He's going to be entering his senior year at H.D. Perry High School. He is on the football team. During the summer, he does summer workouts. Typically, when the coach has the summer workouts, is from Monday through Friday, about 7 a.m. to 1 p.m. in the afternoon. He lives in Miramar with his mother. His mother is a single mother, supporting him and his 2 younger siblings. I believe his monthly rent at the apartment is $1,000 a month. Obviously, well, his mother, from what he advised me, cannot afford the bond that the court has set as far as the $10,000 bond. We'd be asked you to consider setting a bond, releasing Mr. Luis on pretrial release, Judge.
All right. I'm sorry?
He's currently on conditional release with the Department of Juvenile Justice. He was just released from a high-risk residential program on April 27th of this year.
Thank you. All right, Mr. Lewis, it sounds like you've been very, very busy this year. So in light of the fact that there appears to be cause that you can't keep your nose clean without a court order at this time, the court will maintain the monetary bond, $5,000 on count 1, $5,000 on count 2, $25 on count 3. Good luck to you, sir.
Judge, our last request is, would you sign an order allowing Mr. Lewis access to his phone so he can retrieve the phone contacts so he can contact the family and let him know where he's at?
I'll leave it up to the Broward Sheriff's Office. What's been their position as to the?
There's never been any issues. I've never had any objections, and I've never heard of BS having any issues. I believe they monitor it.
All right.
Right.
If you need the court order, I'll go ahead and sign it today.
My colleague will prepare one.
All right. Thank you. Christopher McCall.
Yes, ma'am. Your Honor.
Judge, on Christopher McCall, he was a reset from yesterday, and we were acting on count 3. That came through. It should have been set at $100.
Okay.
I don't know if they fixed it.
Mine's showing $100. All right. Good morning, sir. You're currently before the court on an attempted burglary of a dwelling under case number 186279 CF10A, as well as a felony capias under case number 186279 CF10A on count 1.
And Your Honor, if I may, before the court sets a bond.
Sure.
This is a change of charge. Excuse me. When he was first arrested, he was arrested for burglary of a dwelling. The state filed it as an attempted burglary of a dwelling. He was arraigned yesterday by Judge Dennis Bailey. If I can provide the court with a copy of the original findings from Judge Arlene Backman and the original probable cause affidavit. She set the bond at $25,000, but also if you look at the probable cause affidavit, it clearly states the officer wrote attempt in parentheses on the charge. So there's reason to believe that Judge Backman was aware that the allegation was an attempt when she set the bond. Therefore, I'd be requesting that the court place the $25,000 bond back on Mr. McCall, and any further bond modifications could be heard by Judge Bailey.
All right. Any response?
Judge, I don't think Mr. McCall is going to be able to make a $25,000 bond under any set of circumstances. Mr. McCall, is there any amount of bond you can make?
No, sir, but I'm trying to figure out the charge, the misdemeanor charge, if I can get that resolved today, if I can.
I'd advise you not to do that, as that may have an adverse effect or a bad effect on your other charges.
Would it go with the other charge, basically, if I'm trying to figure out that, because I don't know what's going on with that charge.
I think your best bet, Mr. McCall, is to appear in front of your division judge and try and work it out there.
Would I have a lawyer for that?
You have a what?
do I have a lawyer for that charge or that other charge, basically?
If I could have 1 second, Judge.
Your Honor, just so he's aware, both of these charges are filed together. It's
All right.
not, there's not a
Sir,
separate misdemeanor.
sir, we're not going to separate them out, okay? They're filed together. So the
Okay.
same felony judge is going to address both charges, okay?
And Your Honor, just so you can see what I was referring to, I'm having the documentation I was referring to brought up so you can just see for yourself.
Okay, thank you. So $25,000 bond was set at magistrates on a straight burg dwelling?
Well, it was charged as a burg dwelling because they can't charge someone with an attempt because they can only put one statute number in. But if you, one moment, Your Honor, and let me correct myself. You know what? Your Honor, I think this is with a different case. So, you know, Your Honor, there wasn't any language of attempt, so I do not. If Mr. Reedy wants to present information, I don't have an issue with the court reviewing the bond in this matter.
All right, yeah, I don't see it here.
Yeah, no, I think it was confusing with another case, so I don't have an objection in light of that.
Excuse me, Your Honor, sir. Ma'am.
Give me just a moment, sir.
Mr. McCall, anything that you say is going to be recorded and taken down, so I would encourage you not to discuss the facts of your case.
Yes, sir.
I mean, if you want to talk about bond-related matters, that's one thing.
All right, sir, at this time, the court does find probable cause on an attempt. We'll set a $10,000 bond on count 1. You have a $100 bond on count 2. They appear to be the same case number, though. Is that going to create a problem? Just the paraphernalia?
Yeah, just count 2
Okay.
of the felony case.
All right, you'll see your division judge, sir. Good luck to you.
And you do have an attorney, as you know. Mr. Fortich has, I believe, been to see you already, sir.
I'm trying to figure out that will he be on the same case? That's what I was trying to figure out.
Yeah, he'll be on all your cases. He'll be on all the charges, and you know he can help work out a resolution for you.
Okay.
Okay.
Thank you, sir.
Good luck to you, sir. All right, Earl Outlaw, is that a medical reset?
Yes, Your Honor.
Daniel Diaz?
Yes. Not fired, Your Honor.
Good morning, Mr. Diaz. You're currently before the court on one count of aggravated assault on a law enforcement officer or firefighter. This was a down file?
I think it's actually an up file, Your Honor, because it was an aggravated assault of deadly weapon, and it was filed as aggravated assault on a law enforcement officer. Your Honor, I'm reviewing the original findings in the probable cause affidavit. Bond was originally set at $5,000, and while in the original probable cause affidavit he wasn't charged with aggravated assault against a law enforcement officer, it's clear in the body of the report that the alleged victims were law enforcement officers. So even though it's been up-filed, I'm asking the court to keep the $5,000 bond in place.
Okay, any argument?
Well, in speaking with Mr. Diaz, Your Honor, he's not going to be able to make any kind of a monetary bond. He does not. He has been a resident here for the last 10 years. There's no one for me to call to try and get him out of custody. The only way he could be released is through pretrial release, so we're going to ask the court to consider that.
Did you give me a risk assessment on Mr. Diaz? Did you give me a risk assessment on Mr. Diaz? Oh, you're right. That's okay. All right, are you showing any prior record?
Yes. Well, as far as Broward, trespass 2017, possession of cocaine 2016, possession of cocaine 2016, possession of cocaine 2016, possession of cocaine 2016, burglary of a conveyance 2014, possession of cocaine 2013, tampering evidence 2013, possession of cocaine 2013, burglary of a conveyance 2011, and just so the court knows, you just have the aggravated assault in front of you, but he's also been charged in this case with burglary of a conveyance, battery, and resisting without violence.
And what are the bonds set on those cases, on those charges?
They are...
Thank you. All right, sir, at this time, the court finds probable cause on the change of charge, aggravated assault on a law enforcement officer. At this time, the court will set $2,500 bond on that count, and you'll see your division judge. Good luck to you, sir.
Oh, no. Still forward.
Daniel Santana.
Oh, my God. Sorry.
Daniel Santana.
Medical loan?
Medical? Yes, Judge.
Christian Adams.
Medical reset.
Oh, that'll be a new record. Derek Francois.
Medical reset.
Tyrese Grant Campbell.
He's approaching, Judge. He's here at Maine.
Your Honor, I had requested Judge Singal reset this case from yesterday afternoon. I wanted to provide and some additional information, and I've provided a supplemental report, Your Honor. Just to clarify and specify the allegations of the armed burglary, that Mr. Grant Campbell was actually inside the vehicle while armed.
All right, sir, you're here before the court on 2 counts of aggravated assault with a deadly weapon, 1 count of burglary of a conveyance, and 6 counts of juvenile pickup orders. The court does find probable cause on all charges. At this time, the court will set a $20,000 bond on count 1, $20,000 bond on count 2.
Your Honor,
Go ahead.
Before the court makes any determination on count 3, since it's a punishable by life offense, the state was going to be seeking a no bond hold upon the finding of proof evident or presumption great for first appearance purposes only.
All right, any argument, Mr. Reedy?
Your Honor, in light of the fact that Mr. Grant Campbell is currently being held no bond on the juvenile pickup orders, we would defer any argument regarding proof evident presumption great until he can appear in front of his juvenile judge and his division judge.
All right, thank you.
And Your Honor, I'm sorry.
Go ahead.
No, please.
All right, sir, at this time, the court has reviewed both the probable cause affidavit as well as the supplemental report. Does find proof evident presumption great at this time. Orders you to be held no bond on count 3, armed burglary of a structure or conveyance, and you have no bond holds on the juvenile pickup orders.
And Your Honor, I would just be in an abundance of caution requesting additional release conditions of no victim contact and no possession of firearms or weapons until further order of the court.
So ordered. All right, sir, you understand as part of this court's order and part of your conditions of release, if you post bond, is you're to have no contact with a listed victim in the case. a Miss Giselle Leon. You're to possess no firearms, ammunition, or concealed weapons permit. Any violations of those conditions could result in your rearrest. You understand?
Yes, ma'am.
All right. Thank you. Good luck to you, sir. Haley Cadeau.
All run.
All right.
All right, good morning, sir. You're currently before the court on one count of lewd and lascivious conduct on a child between the age of 12 and 16.
I can't see you.
On a child between the age of 12 and 16. The court does find probable cause on that count.
Your Honor, this was actually downfiled.
What was the bond set on the original count?
Originally, it was set at $7,500 by Judge Gottlieb at first appearance. I'm actually, even though it's been downfiled, I'm still going to be asking for a bond increase. The reasons being, Your Honor, I provided the court and defense counsel with a supplemental report that was not available to Judge Gottlieb when he set the bonds. I believe this includes a statement that was provided by the victim's mother, Mr. Cadeau's sister, and I believe this information is of an aggravating nature, and it's certainly a change of circumstances from what Judge Gottlieb knew. Additionally, Your Honor, when Mr. Cadeau was arrested, and frankly, I don't know if Judge Gottlieb took this into consideration or not, but it's a change of circumstances. When he was arrested, he was being held on a 948-06 violation of probation for felony DWLS. Since his arrest, Judge Scheer has deleted the hold on him, so he's not being held no bond on a separate matter. So because whatever bond the court does set is ultimately going to be, since there isn't something else holding him in custody, and I do have concerns for the alleged victim's safety, Your Honor, I would be asking the court to reconsider the $7,500 bond for a bond increase.
All right, any response?
Judge, I think the only thing that's different is Mr. Cadeau's mother indicating his previous history, which apparently the family never took any action at all to get him any help. I think Judge Gottlieb was well aware that Mr. Cadeau gave a statement regarding his involvement in the incident. That would appear to be the determinative factor in probable cause and in the bond being set the way it was. I don't think the addition of this material or these additional facts substantially change anything that's already that was already before Judge Gottlieb. Mr. Cadeau has been a resident of Florida for all his life. He's not going to be able to post any kind of a monetary bond under any set of circumstances, Judge. I'm going to ask for pretrial release because that's the only way he can possibly get out. But as far as increasing the bond is concerned, I just don't think that there's such an additional amount of information now before the court to make that appropriate.
Your Honor, and I apologize. The copy I had, it wasn't clear. I just confinement status showed me. Frankly, it makes more sense. Judge Gottlieb said a $75,000 bond. My copy, one of the zeros wasn't showing, Your Honor. So, in light of that, I would be asking the court to keep that bond in place. I think that's certainly appropriate.
Well, again, Mr. Cadeau is not going to be able to come anywhere near that bond, Judge.
And I just want to note, Your Honor, because Mr. Reedy represented that the family never sought help, but rather the report actually says that he had been taken to counseling several times and that there were no changes.
So it also indicates the mother stated that his behavioral issues were always swept under the rug.
All right. Respectfully to both your arguments, I think that that argument actually elevates the safety concern here. The court was provided with supplemental information in court today to include information that this may not have been an isolated incident of sexual misconduct with a minor. So at this time, the court is setting a $75,000 bond on the amended charge. Further, Mr. Cadeau, the court is going to order that you have no contact with the listed victim in the case and that you further have no contact with any minors under the age of 18. You understand? You understand,
Yes,
sir?
ma'am.
Okay.
And
Go ahead.
since he's not facing a no bond hold, would the court consider pretrial release with a GPS monitor?
I would. Sir, at this time, the court is additionally going to impose that if you do make bond, you are going to be monitored by pretrial services level 2 with a GPS monitor to ensure that you're not going to inappropriate places and that you're not making inappropriate contacts, okay?
Yes, ma'am.
All right, sir, you'll see your division judge. Good luck to you, sir. Trevon Suarez.
Your Honor.
Good morning, Mr. Suarez. You're currently here for one count of robbery by sudden snatching.
Good morning,
This was a down file to a third degree?
It's technically a down file, but I provided the court with Judge Malika's original. It was originally a missbook. Judge Malika, when he had his first appearance, found probable cause for sudden snatching. She actually wrote it in. I believe I provided the court with a copy. She wrote in by sudden snatching and set a $2,500. I'm sorry, it was Judge Barner, and set a $2,500 bond, considering that she found probable cause for the charge that the state filed, and that he's before the court on now. I would ask that the $2,500 bond be kept in place.
Mr. Suarez has a no bond hold on count 3. It's a violation of probation. So whatever bond this court sets, he's going to have to go in front of his division judge anyway.
All right, sir, at this time, the court does find probable cause for the down file. The court is maintaining your $2,500 bond. You'll see your division judge. I'm hearing you have a no bond hold. That's not for magistrates today, all right? Good luck to you, sir. Nathaniel Cunningham.
He's here at Maine, Judge. Good morning, Your Honor.
Good morning. All right, good morning, sir. You're currently before the court on one count of second-degree robbery. This was an up file from an attempt?
No, it was changed to an attempt, and I believe this is the case I was referring to when I
Oh, I'm sorry, sir.
earlier.
You've been down filed to an attempted robbery.
This is the case I meant to, that I was talking about earlier, Your Honor. I provided the court with Judge Litter-Wren's original findings and the probable cause affidavit. And if you see on the probable cause affidavit, in parentheses, the deputy wrote attempt. It just can't, they can't book it as attempt upon arrest.
And what was the original bond set?
It was set at $25,000.
All right, any significant change, Mr. Reading?
Judges, you can see he's still here in custody, so no one's going to be able to afford his monetary bond. He did advise me he's a handyman by trade, making about $60 a day when he can get work. He lives with his mother's on disability, so financially nobody's going to be able to afford the $25,000 as evidenced by him still being here. Judge, would you consider a bond reduction of a combination of maybe a $2,500 bond with supervision with free trial release, Judge?
Does he have any history?
Michelle, you don't have any notes, do you, by any chance? Yes.
2014 conviction for sale of cocaine.
And Your Honor, just, and noting the allegations in this case involve, the allegations also allege that Mr. Cunningham attacked this woman, and after she fell to the ground, he continued to kick her in the face and rib area until she momentarily lost consciousness. I do believe the bond the judge, even as an attempt, which frankly was an attempt. Thankfully, there was a Good Samaritan there, a witness that began honking her car horn, which caused him to flee the scene. If she wasn't there, who knows what would have happened. I think the bond that Judge Loren said is quite appropriate.
And in light of Mr. Cunningham's history as well, I tend to agree. At this time, the motion for pretrial release is denied. The court will set a $25,000 bond on count 1, a $1,000 bond on count 2. Order no victim contact, no return to the scene of the alleged incident, which is listed at 3690 Davie Road in Davie, Florida. All right, thank you, sir. Good luck. Joseph Carrera?
I believe he was released.
Yes, he pushed it. Yes.
I'll ask. Judge, are you going to be presiding over afternoon magistrate court?
I am not.
Oh, okay.
Do you know what time we're going to be starting this afternoon?
I'm thinking 1:30, but don't quote me on that.
Yes, sir.
Judge, there is another person at Paul Ryan. It's Heaven Jones. She's on page 5 of our docket. We don't have any paperwork.
I don't
It's
see
an
anybody.
additional count of child abuse.
What's that?
She was sitting
Oh,
there.
Miss Jones?
It says no paperwork. We have to get the paperwork and just reset it. She's being held, I think, on no bond.
Yeah, I think so.
We're gonna set it for tomorrow.
Okay, that's fine.
All right. We have a Christopher Engdahl or Tyreek Johnson. Oh, we did.
Tyreek Johnson handled. Oh, Engdahl, I think that was paperwork I left for Judge Simali yesterday afternoon.
Gotcha. All right, so everybody all clear? Main jail all clear?
Yes, ma'am.
Paul Ryan, Conti, North Broward. All right, we're good. Thank you, everybody. We're off the record.